Y'all, y'all, the lights are red. We can't make this stuff up. And I'm live twice in a day because you cannot make this stuff up. And we just have to talk about it. We have to talk about Babs. Babs yoded the motion. Just she noped it. She noped it. And it's kind of interesting. It's kind of epic, and it's kind of funny all at the same time. So we got the high pony. I don't even know if the high pony's straight or not because I was out playing in the snow and I'm trying not to have like a hat hair after the snow. For those of you watching on the replay, there will be timestamps down below. I got some tea. Well, it's hot chocolate because I'm a child. You guys, there's so much going on. There's so much going on. Oh, girl. We're going to get in. We just have to get into it. We have to get into this shit right now, right fucking now. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. So I will timestamp stuff down below. If you're in the live stream, hello and welcome. Do the YouTubey things, the likey, subscribey things. Welcome. Y'all, we are riding on the Tati Westbrook case today because there has been a minute order issued by the judge, which is a ruling. So we're going to talk about it. Here's what I'm going to do. I'm going to break down what happened, what the judge says, what it means, like really what it means. And then I'm going to just answer some of your questions. And then we're going to bunny hop on off and go have dinner. It's just, you guys, if there's anyone you want to see this, go ahead and share it. There are 1,900 law nerds up in here. Thank you. The judge in this case, we have fondly named Babs, but it is Judge Barbara Rothstein. She is a federal judge. So Babs is out of respect and love because we have respect and love for a judge who's just not having it. She pulled this lawsuit over and was like, no, nope, no. What the fuck? No. So let me give you a quick background of how we got here. I have a breakdown of this case, a case brief video. I will link it down below. I will do the card things of the case brief if you want to know the entire background of this case up to the end of January. But here's what has happened since the end of January in the Tati Westbrook versus KJ without a crystal ball defamation lawsuit. Yes, this lawsuit's still about defamation. No, jurisdiction in Washington hasn't been decided yet. Earlier today on Coffee and Cursey Words, we talked about what a different litigation strategy looks like. We talked about the Keemstar case. He was sued by Romeo Lacoste. Keem won. Yesterday, he shared that his attorney fees have been paid, but he settled the attorney fees for a little less because he also took Romeo Lacoste's gold play button. I talked about that earlier today. What we saw was Keem's legal team was like, fuck this shit. We're not even fighting you on jurisdiction. We're just going to win. We're just going to dunk. We're just going to dunk on you. And that's exactly what happened in the Keemstar case. It wasn't even a year. And the case went from filed to Keem got his attorney's fees paid in under a year because they didn't fuck around. His attorneys were like, no, we're not going to do that. But here we are fucking around more in this lawsuit. Yes, we do, Jen Gerard. We love a no-nonsense judge. And the fuckery is afoot. It's DEFCON what the fuckery at this point. That's why we're red. Because what the fuck? So we're still in a jurisdiction like motion. That has not been ruled on. The judge has not said there's jurisdiction here in Washington. In the course of this motion for jurisdiction, there have been precipes, which are the motions to include more shit, like oh wait, there's more. And there have been precipes from Brown, one of them was like 300 pages long. There have been press-a-pays from Lorianne and from Nat. There's hacking. There are death threats. There is so much off the rails in this case. And then last week, Brown came through with a motion for sanctions, which is the ultimate, like, fuck you to the other side's attorney. Hey, fuck you. I think what you've done is bad enough that not only do you need to pay attorney's fees, and likely you need to report yourself to the state bar. So fuck yourself. That is exactly what the motion for sanctions is. Then there was a motion to shorten time to file Rule 11 sanctions, which is slightly different than the original motion for sanctions. It's just saying, okay, the person who signed these is the one essentially responsible. What we learned in the original motion for sanctions is all about Brown's resume, that he charges $450 an hour, that $450 an hour isn't a reasonable fee for him, that he has been doing all of these things, and he has spent 40 plus hours on the motion for sanctions. The motion for sanctions is about essentially the Lorianne Declaration. Brown's argument being, hey, we had 80, 70, 100, 150 emails with Lorianne and 2 phone conversations that were like 18, 20 minutes each. And over 18 days, we vetted Lorianne. And then all of a sudden, she said all this other shit to Saltsy, and they talked on the phone for only 11 hours. And then he filed this declaration, and it's reckless and it's abusive, and it warrants sanctions, and he should either withdraw it. It's kind of a force your hand, like withdraw this or we're going forward with the sanctions. And a Rule 11 motion allows 21 days for the declaration to be withdrawn, or for there to be sanctions, or for there to be a hearing. The thing is, for me with the sanctions, it's a bit early. It's a bit early. Sanctions can always come down the road, but it seems to me this is a play to get the court to really evaluate and maybe kick out this Lorianne Declaration, because the Lorianne Declaration really has strong ties to Washington, and that does go to this motion for jurisdiction. So this morning on Coffee and Cursey Words, we just talked real briefly about this Rule 11 motion that had been filed. It's like, hey, there's this Rule 11 motion to shorten time. Brown's argument being, hey, if the court rules on jurisdiction in our favor and kicks this case to Minnesota, then you won't have the authority to sanction Saltsy, and we want you to sanction Saltsy. So you should shorten the time on the Rule 11 motion so that it can be heard faster, so that if you let us go to Minnesota, you can sanction him first. Please, 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 please sanction him first, because we want you to know that he sucks, and we want this Lorianne Declaration thrown out. So that's where we're at with this. And then that was filed yesterday. Then today, yesterday, by the way, being a, federal holiday with President's Day, the judge came down this afternoon and was like, no, that's not happening. Sounds to me like KJ just took more money and threw it in the trash. I've never seen someone dislike money as much. I mean, somebody paid for this Rule 11 motion, and let's pull it up. The court said no. The court said no, and I'll tell you why the court said no, because the reason the court said no is rich. It just is. So we are now at 62 docket items. This is the court's minute order. Motions to shorten time have been abolished. Local Rule 6B. The court therefore strikes the motion to shorten time, meaning nope. We're not hearing it. We're striking it. And then it shows up down here, stricken per minute order, motion to shorten time. No. You can have your Rule 11 motion. You cannot shorten time. Why? They're not allowed. You're not allowed to bring a motion to shorten time. You are not allowed. This is the 2021 version of the local rules. Local Rule 6, computing and extended time. Motions to shorten time have been abolished. This is not a new 2021, though, rule. This is an existing rule, a local rule, where an attorney who is a local practicing attorney should know the local rules, just like they should know the standing order. And not only should they know the local rules, but at some point they have an associate who should be like, excuse me, but we can't. I know that you want to, but we can't, but we can't. But we can't, but we can't, but we can't, but we cannot file the thing because the thing has been abolished. It is not allowed in these courts. It is not allowed It is not allowed. This is why when you have counsel like Saltsy appearing pro hoc vice, meaning I am licensed in California, in the example of Saltsy, I am licensed in California. I am appearing for my client in Washington. They hire local counsel in Washington to do things like tell them what the local rules are. That's the point of having local counsel, to adhere to the local rules. And the local rules are on the court website. It's one of the things they tell you in trial practice. Any 1L will tell you that if you're appearing in a court, what do you need to do? You need to read the local rules. Because the thing that the judge get really prickly about are their standing orders and their local rules. So not only do we still have 45-line paper and motions over the page limit in violation of the court's standing order, which is like coming into somebody's house and being like, yeah, we don't give a shit about your rules. We're just going to do it our way. Not only do we have that, but now we have the local rules not being adhered to. And the thing that's so rich to me is that with this counsel, he's brought this entire motion about bad faith and shit that Saltsy's doing. Like, he shouldn't be doing this. Okay, but if you're going to bring a motion to shorten time and spend your client's money to bring a motion to shorten time, isn't it in bad faith to bring one that cannot actually be brought in? I know, it's not brought in. It was a reference to bring it on. It was a joke. See, because it's already been brought in. Okay, it was in my head, it was funny and not awkward grammar. But isn't it in bad faith to bring a motion that actually cannot be brought? Y'all, help me. Help me. And look, KJ has absolutely come for me. We absolutely know that KJ is not a fan of Emily, but I don't want to see any client at all pay for shit they shouldn't be paying for. And this is something that no client should be paying for. No client should be paying for a motion that legally cannot be brought at all. I don't care. I don't care what you all think of KJ. All of you should be outraged on her behalf, going, come on. Everyone deserves good legal representation. Everyone deserves to have their lawyer do their best on their behalf. And this ain't it for me. This ain't it for me. Like, why are we blowing money on this lawsuit? How is this the legal strategy? How is this the legal strategy in this lawsuit? I don't understand. I don't understand. It's just wild. I don't understand. And the lawyering here is just so frustrating to me because why is this the legal strategy? I don't, and maybe they all know. Maybe they are like, this is our plan. Great. But I can't see it, and that's fine. I see things how I see things. But why bring a shortened time motion when you can't shorten time? It just makes you look bad in front of the judge. Yes, the sanction motions is still active, but there is no shortening time, which means the judge could still rule on jurisdiction in the meantime. Brown wants this motion heard faster and doesn't want Saltsy to have the full 21 days to respond. But you actually have to not bring motions that you cannot bring. You cannot bring motions. I just don't understand. I just don't understand. I just don't understand. I don't understand why you would do this. It is not, it's just not the thing. When you're practicing in a jurisdiction, you know the local rules. And if you're a law firm partner, you have associates that also check and are like, by the way, motions to shorten time have been abolished in this jurisdiction and cannot be brought. I don't know how this one slipped through. I don't know how this happened. And I don't know what the strategy is here. I understand why they want to shorten time, but you can't. So why why make the judge question you on such a fundamental level? Because this is now, not only do we have the issues with the standing order, and we've seen the judge mention the standing order in multiple minute orders saying, per the standing order, per the standing order. We've had on Brown's end, we have had missed deadlines, violations of page limit, violation of page line enumeration. And you've seen the minute orders say, per the standing order, it's this, per the standing order, it's this. And we've seen the judge give grace saying, for this motion only, we will allow you to respond even though you've missed the deadline. But now you have another example of you brought a motion that actually can't be brought. So now the judge is going to question everything that Brown has said. And I don't know why that's the foot you would want to start off on. Why would you want, not only are you going to have the judge on guard going, oh, did you not know? Like, are you not paying attention to the standing orders? Okay, but are you not paying attention to the local rules? And now I have questions. So this is going to put you on the back foot with the judge and with the research attorney that has to read this going, now I have to look at everything you say. And we talked about this earlier today, the Reddits. There's a subreddit that has the transcript of the court call. And when you look at Nat's declaration and look at what Brown said, Nat's declaration said, they're different. So now you have these inconsistencies before the court that are going to be problematic for them. I don't think Babs is playing. I just don't think I don't think this is going to go well. I don't think this is going to go well. And it looks like it will make it easy for Salty to argue that this motion is brought in bad faith. Like, oh, this is brought in bad faith because you've tried to do this, you've tried to do this, you've tried to do that. Jesus. This is just, y'all, Brown put in his resume in the motion for sanctions. I've done all of this. Let's pull it up. Let's just pull up that motion for sanctions real quick, and then I'm going to answer your questions. Let's pull the motion for sanctions with Brown justifying why he's worth $450 an hour, which for an experienced lawyer, I mean, that's appropriate in the LA market. It might be a little high for the Seattle market, but again, it's the Seattle market, maybe not for a partner with substantial experience. But let's take a look at the declaration of why. I'm going to pull up the resume real quick because it's got the billing in it. And I'm going to find it because I have not redacted this one yet. So let me find where the resume part is. Here it is. All right, let's just pull it up real quick. We can all take a look together, and then I'm going to go through. This is from the motion for sanctions. My standard hourly rate is $450, which I believe reasonable for an attorney of my experience and credentials in the Seattle market. Okay. I graduated Order of the Coif from UC Davis Law School in 1995. That's, 10 years. So that's what, a 25-ish year career. I clerked for the United States District Court for the Eastern District of California. I then clerked for the Chief Judge of the United States Court of Appeals. Those are big clerkships. Those are clerkships indicating that you performed well in law school, that you interviewed well, and that you got good clerkships. Clerking for a chief judge is a big deal on a federal appeals court. Since 1998, I have practiced civil and complex commercial litigation in California, then from 1998 to 2010 in Seattle since 2010. Currently a partner. Great. Attached is a true and correct copy of an October 9th order showing my partner at a $475 hour rate, and then they get into the rate. But that is a resume showing that there was aptitude there and a long history. This is not somebody who is new. This is somebody who has worked in federal court. I just can't. I just can't. I just can't. For me, the also arguing out of both sides of the mouth has just gotten it's hard. It's hard. It's hard. So I saw one of the questions. I'm going to get into questions because I'm sure I'll talk more about this as we get into questions. Did he have to justify his rates for this request? Yes, because he's requesting lawyers' fees paid. Like, hey, I had to bring a motion of sanctions against you, Salty, because you suck. And because I had to bring that motion and because you suck and you did things you shouldn't have done, according to me, then you should have to pay the lawyer fees for it because my client shouldn't have to pay for you sucking. So you should have to pay my fees and I have to show why we do it. So it's just. So I am going to go through and answer questions. I think it's an interesting error because if the local rules, the judge was just like, no, you can't actually do that. I wonder if the research attorney was like this, and the judge was like, what the fuck? You can't do that. And that's exactly what this minute order reads like. This minute order reads, you can't do that. Motions to shorten time have been abolished. You can't do that with a side of, and you should know that. Because you should know that. It's just, it doesn't put him on a good foot with the court, I don't think. And then that doesn't put your client on a good foot. And when you're arguing the other attorneys doing stuff in bad faith, you've opened the door. And that motion to sanctions opened a lot of doors. And Salty has 21 days to walk through those doors and be like, oh, weird. And this. You want to say you want to talk about bad faith? And this. And now it's getting back to exactly what the judge didn't want, which is like, me. The judge said, I don't want to hear like, I'm rubber, you're glue. I don't want to hear you two pissing at each other. That's what was said in that telephone conference. So bringing sanctions right now doesn't seem to be timely, but it doesn't seem to be in anyone's best interest. It seems to be a pissing match, my opinion, because I don't think that the motion for sanctions is going to get the Lori-Ann declaration dismissed. And I don't think Salty's going to go, oh, you got me there. Let me withdraw it. He signed his name to it and put it in. We know from other motions that Salty spent over 11 hours on the phone with Lori-Ann. So in that 11 hours of interviewing, felt confident in her motion and signed, had her sign and submit her declaration. I don't think he's going to withdraw it. I think that Salty probably believes what Lori-Ann said is what she believes is true. And that is her truth. And then what she told Brown is not, because she didn't sign that declaration. I'm sure that's what they believe. I mean, that lawyer speculation, monuments to the gods, but good Lord, y'all. Good Lord. The pre-litigation in this is just such a waste of money. And it doesn't make sense to me. Like I need something to make it make sense, because this type of money burning early in litigation doesn't make sense. It doesn't make sense. Why burn so much money? Is KJ's purpose to just try to outspend Tati Westbrook? And if so, where is that money coming from? Like, that doesn't make any sense. Normally, a litigation strategy is not to, unless we're talking about massive corporations like Facebook and Apple going, fuck you, no, fuck you, burn it down. We have billions. We're just going to burn it all down. That I understand. This I don't understand. I don't understand. Like, Keem's strategy made more sense to me. No, fuck it. We're gonna just strike to the heart of the bullshit. We're just gonna go right to it. We could make motions for jurisdiction. Yeah, we could do all this, but no, we're not. Let's take it down. That legal strategy makes sense to me. This legal strategy doesn't make sense to me. Maybe at some point it will. Maybe at some point we'll go, oh, that's why you were trying to run everybody out of money. But this just feels like tactical money waste to me. And I don't understand why that's a game that KJ would be choosing to play at this point. I just don't. I just don't. I just don't. So Brown's opened another door. There's inconsistencies in this motion that I talked about earlier. There's inconsistencies in the motion for sanctions from Brown's argument. Brown's arguing that these things are being blasted to massive social media audiences, huge social media audiences. But then KJ's statements about Tati Westbrook were just a small channel without much reach. He also says things like the statements in some of these declarations are defamatory, but that the statements that KJ has made against Tati and James Westbrook and Halo are not defamatory. So every time that comes up, I'm like, do we really want to where are we pegging what you're calling defamatory and not defamatory? Because again, you're trying to defend a defamation case saying it's not defamatory and it's opinion and it's commentary, but then you're calling some of these declarations defamatory and yikes. So what do you guys think Salty said when he saw the minute order? I'd love to hear it in the comments while I'm asking some of your question. What do you think the reaction was? I'm very, very curious to see. I'm going to go through and answer questions. Just put question before it so I can see it, and we will go through it. KJ probably has Brown so frazzled he doesn't know if he's coming or going. I bet she were. I mean, and that's where client control comes in. He's been a practicing lawyer for a really, really long time. So I don't know. He did, Cherie. He put his whole ass resume in there. He's like, I clerked for a federal judge. I clerked for the district court. I know the things. Not the local rules at the moment. Yikes. I couldn't agree more, Interest Fairy. I couldn't agree more. And look, I've said this, even in criminal law, there have been defendants who I have had very strong feelings about the things that they did. But I always thought that they deserved the best legal representation that they could have and always wanted them to have that. And most prosecutors I know felt the same way, because if you win a conviction against someone who's done awful things, you want to make sure that they had the best representation possible. So you know that that conviction is a solid conviction, that you know that they got the best defense that they could get, that you know that when a jury came back with a guilty verdict, that guilty verdict is because a jury believed beyond a reasonable doubt the things they're accused of doing are things that they did. And that's the same here. I'm sure there is some part of Salt, though I'm sure there was a giggle about because look, I would have laughed. If I was opposing counsel, I would have been like, you got to be fucking kidding me. But then again, if I was opposing counsel, I would have probably known that when the thing was filed and would have been like, well, let's see what the judge has to say about this. I didn't look up the local rules on it because I never would have thought that somebody would have filed a motion against local rules. So, but it also is like, when you're dealing with opposing counsel that does stuff like this, it's like, fuck. My record has to be perfect because this goes up on appeal. I want to make sure it's clear what I am and am not doing, because some of this stuff doesn't make sense. And that's really, really frustrating. So it is, Robert, it is a circus at the moment. I didn't think that this is where we would be. I didn't think that this is where we would be. I mean, I didn't expect an experienced lawyer it's not like he's a solo attorney who just is like, oh, I didn't know. I don't practice in this jurisdiction. Yay. I mean, I assume that 450 is fairly standard. I do. But assuming that other motion took at least an hour and probably more, okay. I don't understand the play for the money game. I don't understand the play for the money game at all. I am also so confused. Oh, Julie, every live. It is what it is. I go live. People dislike. They say, they watch, they don't. It's engagement, whatever. Mom used the scary voice to yell. Yeah. Babs is like, no, that has been abolished. You cannot file that motion. Counsel, what? That is what that was. That is what this was. Am I over this yet? Yes. Yes, there are moments that I am, but I never thought I would see shit like that. I just didn't think I would see that. This I did not see coming either. There's a lot in this case I haven't seen coming, but filing a motion that can't be filed, I did not see coming. I did not see coming. Suzanne, I'm waiting through ads because under 100K subs. Thank you. Emily, this is not a surprise. I'm a little bit surprised, and you can, if you're watching live, go ahead and skip them on through. Seattle lawyers tend to be pricey because they're defending the tech market. That's also a very, very fair point. I would have to wonder, lawyer, resume lawyer. I just don't understand how this got through. I can't even muster a kind creep show, bless his heart. I just can't even muster it because I just don't even know. I don't. Yeah. Yes, Emma. The motion that all of Brown's, all of them, they're all on 45 line, all on 45 line paper. They sure are. Every single one. I don't know how you continue to ignore the standing order. Order of the coif. No, not the fish. Coif. COIF. It's wild. Okay, let me try to get to a few of your questions. Go ahead and put question in there so I can see them. I'm a little bit behind on questions, so I'm going to try to speed up and get to them. I was going to go live on Insta, and I went on Twitter and did a poll, and a lot of you all were like, look, I don't use Insta. Can we just go on YouTube? And then NJ, my chief Emily officer, was like, but you are a YouTuber. Can you just go on the YouTubes? Because people are going to have questions. And then this way we don't have to talk about it on a Friday. And then the mod squad was like, yeah, we cool. Like, we cool. Let's go. We're cool. Let's just go. And I was like, okay, we'll just do it. We'll just come on over here. My chat just jumped again. So it doesn't say in the rule that I have when it was abolished. It's a fantastic question, Rue, but it doesn't say it. It earlier than last year. I can look it up in just a second. So Brown and Salty have a relationship that predicates this suit that is driving some of this behavior. I have no idea. It feels that way, but I don't know. So I think Salty will take every single minute that he has to respond to this. Absolutely agree. Just to confirm, the other motion is allowed. Yes, the sanction motion is fine. All that the judge has thrown out is hey, we want to make it a shorter time. We think we need less. We need the judge to hear it faster. And the judge was like, you can't even fucking do that. No, we're not doing that. That's what we're not doing. Space Odyssey. Is it possible that Clark Swanson is paying for KJ's legal fees? Look, that would be a strange and odd circumstance if that were the case. I just can't imagine why, unless Clark is trying to burn Tati out of money before Halo gets to the thing. But Halo is also in this lawsuit. So Halo, I'm sure, is also paying for legal fees in this suit. So if you're a partner of Halo, do you want to blow Halo out of money? Or if you're just so mad at Halo, it's like, fuck it, spend all the money. We'll hit you on two fronts. I don't know, but I will say, for what it's worth, and for those of you that are interested, Bea Lucille has a tarot reading about this case, and her card for Clark Swanson keeps coming up in both cases, in the business partner case and in the KJ case. And it's just curious to me that keeps happening. And I will link her channel as well. It's curious to me that keeps happening. Is it possible? Anything's possible. Would it be fucking wild if that were the case? Yes. Would that be the stuff of like Netflix original and Lifetime movies? Yes. Like can you imagine it? Monuments to the gods of speculations. Like the scorned business partner starts footing the bill for another lawsuit just to try to run people out of money. Could you imagine the wildness? What do you guys think? I want to know your conspiracy speculation on that. I mean, anything's possible. Can anything be brought against Brown for filing this? The judge threw it out. I think it's more I don't know. I feel like there's no there's no value in this fight right now with regard to this Rule 11 shortening time motion. It just puts the judge on notice that this attorney is doing things that need to be kept a close eye on. Like if I were the judge, I'd be like, why in the fuck you can't do that. Like there's local rules. What are you doing, counsel? It's going to tip the scales. The judge seemed annoyed on the phone call with some of the stuff going on Twitter that was represented to her by Brown. And I wonder if this is going to make the judge look more closely at the things Brown represents to the court. And if it's going to give Salty an opening to be like, these are the things he's represented to the court that you can bring this motion. He's represented to the court that Nat's declaration says this when it in fact says this. He's represented these things to the court. So how do we just trust these representations? I think that's the direction that might end up going in. Is there an end in sight for Tati? Can we expect her to return to YouTube at some point? That's a better question for the Tarot channel than for me. I have no idea if she can at this point return to YouTube amidst all of this, if that would be healthy for her, or if she would just be bombarded with questions about this that she can't answer. If she returned and didn't talk about it and was like, hey, this new thing came out, let's just review it, and ignored it and set the tone that we're not talking about this, I don't know. It just depends on what her and her legal team decide is best. At some point, if she's going to return, she has to return. I'm waiting to see this case come up in 1L classes. Me too. I volunteer as tribute. Law professors, call me. I want to help write fact patterns. Like, just call me. I want kids at Harvard Law 1L to read this fact pattern about YouTubers. This needs to be Civ Pro exam. It's just amazing. When this becomes a made-for-TV movie, who should play you? Me. Just call me. Let's do it like documentary style. Let's just do it. Let's have a conversation. The Honorable Judge Babs is a boss. Yeah, she is. She wasn't having that at all. I'm sure her research attorney was like, are you fucking kidding me? I will say, I was a research attorney for a year. There were definitely attorneys that annoyed me more than others. I generally gave a pretty fair shake to people because at the end of the day, attorneys are trying to represent the best that they can for their clients. That is their job. And I respect that job tremendously. But when it was like fuckery time and time again, I would just be like, ugh. And then the ones that would call you all the time or email all the time and be like, did you get this? Did you get? Yeah, I have a lot of cases. Give me a minute. And the little things start to chafe as a research attorney. And I think after 45-line paper, you would look at this and be like, no, you didn't. No, you didn't. No, you didn't. No, you didn't. And Your Honor, no. And the judge would be like, yep, nope. And then you would write the minute order. And that's what happened. Does this actually happen a lot in courts? I mean, not from local attorneys. Yes, there are people who don't get the local rules. They're not normally the local attorneys, which is why if you're appearing pro hoc vice, you have to have a local attorney. And which is why if you're representing people in more than one county, you have to read the local rules, because some judges will just let you know that it makes you look like a boob. And they will tell you, this makes you look not great. Counsel, what are you doing? They will call you out. You think Salty just giggled and proceeded to pick up dinner on the way home. Michael, I'm trying to formulate the question. When do you see them dealing with jurisdiction? I don't know when the court's going to deal with it. I would love for the court to just drop a ruling so we can just be done. But I don't know. I don't know when the court will deal with it. The noting dates are done, so the court has the time to read all the motions, consider it, and rule on it, or ask for more argument, or ask for a hearing for argument. Is it possible that Brown and Salty had a relationship previous to this case? Anything's possible. Anything's possible. Why file a motion that can't be filed? Jessica, I don't know. I only can imagine that he didn't know that it had been abolished per the local rules. I can only imagine that. What does abolish actually mean? It means that that motion can't be brought in the state. It is now not illegal, but it is not possible. It's like, no, you just can't do that. There are no motions to shorten time. They are not allowed in this jurisdiction. You cannot bring a motion to shorten time. There used to be motions to shorten times. We abolished that rule. It's like abolishing abolition or slavery or you get rid of a law. It's to make a law invalid. You get rid of it. You abolish the law. Can you please ditch your mod? No, lemonade stand. I cannot. I very much like my mods. Question, why isn't Brown being pulled into line for not meeting the local standing orders? Surely there must be consequences. I'm sure that the judge will have some words next time because there have been issues with her standing order. I'm sure it will be brought up. In minute orders, it was said, this was said very plainly, like, no, we're striking the motion. You cannot do that. What would happen if KJ dropped Brown and a new... yes, but the court at this point, I think, would make Brown stay through the end of at least the motion to dismiss because there's no way. Brown to Lori, he was working with her for free, so can he legally present a bill? Brown said he would, but then he also continued to say he never represented her. So no, he said, I'll help you do this. I'll help you do that. He was trying to assist her and then trying to get a declaration from her. So no, I don't even think there was a fee agreement. There's not much that can be done there. Do you think Brown is using this to get the fuck out of this lawsuit? I mean, attorneys have the right to just do that, though. You wouldn't do this way. You have a right to say, hey, I'm no longer working on this and go to the court. I don't think that that's what's happening here. So I don't think. Hi, are you making hot chocolate?
No.
Am I making hot chocolate?
We're saving it for tonight because it gets colder and colder in Tennessee.
It does get colder and colder to Tennessee. I'm live. Can you say hi?
Hi.
Okay. Did you have fun in the snow today?
And plus, the snow tower we made is just completely ice.
Yeah, we didn't make the snowman very well, and now it is completely iced over because we didn't know.
Because
it was sleet. Y'all let me know.
The problem was we couldn't make the snowball and there wasn't enough snow to make the ball.
Yeah, it was sleet and it just kind of all froze over. All right, why don't you take that back to the kitchen? I will be done soon. Wait, did you say bye to the Lawnards?
Bye.
Wait, no, come say bye. Come say bye.
Bye.
All right, bye, honey. Close the curtain. Hey, I got you. You got to close the soundproofing. Sorry. Snow day life. All right. Question, theory, speculation. Love that. There's been speculation that KJ had a connection to the business partner. Maybe she's gotten something more there that makes her want to play money games. I don't know. Maybe. And I've seen that too. I've seen the videos where she alludes to having information directly from the business partner. That's where my initial speculation about it came, because there were things in both of the lawsuits at the beginning before I was even familiar with who KJ was. When you read the two lawsuits, there were statements in the business partner suit that rang very similar to what was being alleged in the defamation suit, almost as if parts of the defamation were bases for Clark's suit. It's just the way that these two suits play together for me is strange, and it feels too interconnected. And there's just something there that we all can't quite see. And that's how it feels to me. It's like there's something there, but we don't know exactly what it is. Do I think that KJ had advanced knowledge of the business partner suit getting filed? Absolutely. Is there anything wrong with that? No, there's not. The reason it was a problem for me is just because I saw the videos of her saying, I got tipped off by somebody at the courthouse. And that was, to me, not accurate because, one, the courthouses are closed for COVID. And two, the time when she said that was going down, the time stamp on the lawsuit doesn't match up with the timeline of what she said. Could she have been mistaken? Maybe. Could she have just been given a heads up that the suit was coming and had an advance copy of the suit? Yes. Did I ever see her pull up the document of a suit with the filing stamp on it? Not that I saw. She read the suit and talked about what was in it. So could she have gotten that from Swanson? Yes. She broke the story. It's in this lawsuit everywhere. In the motion to dismiss, she broke the story. She broke the story. She broke the story. Great. Is it okay to have a heads up that something's coming? Yes. There's nothing wrong with that. The only issue I took with it was, yeah, but the story of like, oh, I had a courthouse watcher that told me it was there. That didn't match up to me because no one's in the courthouse and it was electronically filed. And So an electronically filed document goes into the system. It doesn't even go through somebody that would see it being filed. Like, ooh, something came across my desk and I stamped it filed. That's not how that works. So no, the judge didn't throw out the sanction motions. The judge threw out the motion to shorten time with an epic, like, no, you can't do that. Know the rules. And that's the most interesting part, is the lack of knowing the rules. Hey there, Dr. Cross. So that's the most interesting part for me. Does KJ and Tati have to regularly pay a lower bill, or do they wait until the verdict and pay one large sum? Oh, Michael, that's a fantastic question. Generally, attorneys will bill, depends on the type of fee arrangement. We know a little bit about the fee agreement with KJ in this case because there were billing statements attached. It looks like they're doing a monthly billing. Because some of those statements had KJ's address on them, I'm not showing them here, but it went through the time that they took to deal with the Barnhart declaration, stuff like that. So lawyers bill. This is clear that the attorney is billing in a billing fashion, so by the hour or by the fraction thereof, not on a contingency. So it's not like, if you win, we will take part of your winnings. This is you are paying for these legal fees monthly. At the end of the month, you normally get a billing statement saying this is how much you've spent this month. And this case is well into the six figures in my estimation. And once again, that's my estimation. And now, based on the time Brown's taking doing these things, the fact that Brown is billing them himself, and the fact that he's billing at $450. I mean, somebody do the math. This was, let me pull up the hours that he said he worked on this. This was a little over 40 hours on this one motion. So if this was 40 hours on this one motion at 450, I mean, you guys can do the math on how much that is better than I can. But even though those are nice round numbers, let's see. I'm going to see where he said the amount that he spent on this motion. 41.9 hours at $450 an hour. That's what was spent on the declaration and this motion and stuff. So that's what it is. Because so only the motion to shorten time got striked. So yes, Salty has the entire amount of time to respond. Let's see. What can Salty do to not join in on this bickering back and forth? I don't know if there's anything at this point. We haven't seen much of him on Twitter, which I think helps. There haven't been a ton of statements. I have not been paying a ton of attention to what KJ does. There don't seem to be a ton of statements about this case. So it seems that the chatter on social media has quieted down, which is probably a good thing. But Salty is probably going to come in hot with the response on this, because the sanction motions is so personal, and it's like directly targeted at the lawyer. So there's that. Let me try to get to a few more questions. Remember James Charles warning KJ she needed to let things go. It was so much bigger. Well, maybe the so much bigger is paying her lawyer bill. Maybe it is. I remember seeing that after the fact. Oy, 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 oy. Question: if you can represent yourself, can you be co-counsel to file in the lawyer's name? It's an interesting question. I don't know a lot of lawyers that would allow you to file in the lawyer's name if you're co-counsel, but you would need to be on the record as representing. So if you are in a representative capacity, you would need to be on the record in a representative capacity. I hope that answers that question. Do you know why it was already no, it was probably because the courts decided they weren't hearing shortening time motions, because it's a waste of time to hear a motion to shorten time. And by the time you hear the motion to shorten time, you're probably at the time limit anyway. It probably had to do with streamlining the court system. Will anything be heard before the judge will anything heard before the judge be available via telephone conference? It should be. It absolutely should be. And if any more motions get set, we'll hear about it in advance. Does KJ actually have confidence in this team? I have no idea, but at this point, because there are standing motions, to change lawyers would require the court interceding. Is it possible? Again, anything's possible. Let me get to a few more questions. I'm just looking for questions the best that I can and trying to get with them. um Question, can I join your channel if I'm not a lawyer? I want to be a law nerd. You are a law nerd by being here, Kathy. Lawyers are not the only law nerds. There are lots of us that are law nerds that aren't lawyers. There are lots of members. Most of the members of this channel are not lawyers. They are fans. Law nerd is just a fan of the law nerdy things. So yes, you do not have to be a member. You just have to enjoy the shit that we do up here. And then you are a law nerd. With the way things are going, what is your wild guess on how long this case will take to end? I say 5 years. I don't think people have the money for this to last at this pace. I hope that after this unprecedentedly wild motion to dismiss, they will just go into discovery like normal grown-ups in a lawsuit. And it's like, go to discovery. And then the discovery will start and it will take time. I hope that there is some, I don't know, forensic report on what's going on with all the computer shenanigans before then. I hope that happens. But then it should just, jurisdiction should be decided, and then it should just go into discovery, and then it should be quiet for a while, generally. Do you think KJ was pushing for it? I don't know. And if that's the case, then if that's the case, then that's the case. But the problem is it puts the lawyer on the bad foot. And generally you say to your client, I know you want to do that, but we can't. And here's why. There are statements, they're just cryptic. And that's fair too, uncovering hypocrisy. And that's where I'm sure it will get brought up again. If there is stuff being said, I'm sure it will come up because everything's coming up. Am I the only one that feels that Brown is trying to shorten Saltz's time is kind of mean? Yeah, it is. I feel like Brown is trying to push Saltz to withdraw the Lori-Ann declaration. Like there's a game of chicken going on with the Lori-Ann declaration. It's not really about sanctions. Sanctions are hard to prove. I don't think this is really about sanctions. I think this is about trying to play chicken with the Lori-Ann declaration and get him to pull it out. Thank you, all things. He is a sweetheart. So I appreciate that. Thank you, John. Over $18,000 to respond to the Lori-Ann declaration. Fantastic. Question, when is the 21st date? What date? I didn't do the math yet, but I will sit down and do it. It would be the date since it was filed. And I need to look at the courts because the court's standing order is 21 days too. But it would be 21 court days from the 10th of February. If that helps. Since this sanctions deals with Saltz's character being questioned, does Tati have to pay for his reply? Yep. When your lawyers are in the lawsuit, you have to pay for the things that the lawyers do. Will he choose to bill her at his full rate and stuff like that? I don't know. That's a conversation he will have with his client, I'm sure. Is Brown going straight for sanction motion pretty hardcore? Yes. Yes, it is. It is definitely ensured that these attorneys cannot work kindly together, but those bombs started being lobbed. I think Salty was the first one to call something in bad faith, and I believe it was the filing of all of those videos, like the huge list of requests for judicial notice of the PewDiePie video and the Trisha Paytas video and all these other videos. I think that was the first thing. It was like, this request is in bad faith. You can't even take judicial notice of these things. They're just in here to be a further smear campaign on Tati. I think that was the first bomb thrown. But these attorneys have gone hard this whole case. And I think it really started with my perspective and opinion. I think it started with the deleting shit and the motion to not delete your shit. I think having to bring that motion so early breaches trust, because it's like, no, your client can't do that. What is happening? And it puts parties on edge. And that's even before Brown came into the case, because he didn't appear on the record for maybe a week or so after that, maybe 2 weeks after that. So that's all in the breakdown. I have all the dates in the case brief. But this case has been on an aggressive foot since the beginning, and it started with that motion to not delete your shit and went from there. So, yep. Could Brown be deliberately trying to? That would be unethical. I hope that that's not what's happening. Green eyed girl. I hope. See, did you see my brain switch in the song? That shouldn't ever be the attorney's goal, and I can't imagine that would be the case. That would be just not okay. If they have a case strategy to burn through money, it would have to be a discussed, like, this is what we're doing. Question: why would the client have to pay for the lawyer's defense towards a sanction? Because it's still part of this case. The motion for sanctions was brought part of this case, and the things Celti's doing in this case are as a part of this case. I'm going to try to catch up with questions. The Pawnards are living for 2 live streams. Thank you. And I have not been on Twitter a ton, but thank you. When all of this is over, can we please sit down with Salty and Tati? Like, I want to hear Tati's thoughts on all of this. I want to hear everyone's thoughts on all of this, truly. And yes, we can. So, question: what if you can't pay the lawyer? The lawyer can make a motion to remove themselves from the case, and you can represent yourself. No, I don't think so. It looked like it reads to me like it was older than that, but I can research the history on that. Isn't a sanctions order essentially a punishment against the attorney? Yes. It can be ordered monetary or something. Yes, it can. But Amy, they're generally ordered monetary. So the sanctions are generally a monetary punishment, and they can also have state bar implications. So that is what that is. Let me get to, I think I missed a few super chats, so I'm going to try to get to those for sure. This case is just turning into a giant game of Clue. We're trying to figure out who did the crime with that weapon in what room. There shouldn't be this much intrigue in this case, and I think the Twitter nonsense really popped that off too. With regard to the Twitter nonsense, I don't know why that would be going on. I mean, it's just gotten so wild with that. I just don't know. Courtney, those are for the channel members. So you can go to lawnerdsunite.com and do that. There's a join button on the channel. So that's what that is. Question: if they moved jurisdiction to Minnesota, can they use the same paperwork? They would use roughly the same paperwork and kind of redo some of the charges specific to Washington to make them charges specific to Minnesota, and they would have counsel in Minnesota. I'm sure in the 18 months running up to this, if it were me, in the 18 months running up to this, they probably looked at, do we want to file in Washington? Do we want to file in Minnesota? What do the laws look like here? What do the laws look like there? And then how do we want to play that? Knowing that if we do it in Washington, there might be a jurisdiction motion. If we did it in Minnesota, there wouldn't be. Where do we want to roll the dice on that? So that, I think they would already probably have an idea of what they would file in Minnesota if this gets kicked to Minnesota. So we'll see. Yes, right? So close to 6K live. It is crazy. Question: speculation, what the fuck? Perfect. This reeks of an inside job a soon to fail two-pronged approach. Could it be that KJ and partner lawsuit are working together to deplete Tati financially and take her down? It could absolutely be. I think that's what I speculated to earlier. You probably typed this in as I was rambling earlier. Yeah, it could be. I mean, I would imagine some of that would come out in discovery, but anything's possible at this point. The thing that wouldn't make sense for me is that Halo Beauty is also in this lawsuit. So Halo Beauty is probably also paying for legal fees in this. And it's definitely a burn the boats approach to litigation. And if Clark Swanson would be doing that, again, conspiracy speculation, it would really be burning the boats on being a part of Halo Beauty, but it might be like that bridge might already be burnt in his mind anyway. So it's like, fuck it, who cares? But we just don't know. And will we ever know? I don't know. I feel like at some point we will have more insight into this case, but the money burning is very confusing to me. Just based on the litigations I've been a part of, it's just weird. It's just weird. It's weird. There's so much in this case that is just fucking weird. I really think at some point the judge is going to be like, I told you not to make me go through the emails to see who did what to who. Like, stop it. It will come up when the next conference is. The judge will make her mind known, I'm sure. She was very clear. on the last one. I thought she was perfectly clear. Okay, I think I might have missed a few super chats, and if I did, I'm sorry. Thank you for the new members of the channel. Thank you, Monster Mash, for the super sticker. I love the name. Brandy Rose questions, so did Brown just not know the rule or say screw the rules like he's done several times already, and which is worse? As always, you're awesome. Oh, thank you. Thank you for all you do. Thank you for the super chat. I'm sorry I couldn't pull it up on the screen. It timed out before that for me. I can't imagine he would just ignore a local rule knowing that the judge would just call it out. I can only imagine that he just, for some reason, is not aware of the local rules. And I don't know why. Michelle Marie super chat said, sound to me like KJ just took more money, threw it in the trash. I've never seen someone dislike money as much as herself. I think I got to that one earlier. So I hope I didn't miss any other super chats. I'm going to get to a few more questions and then we are going to go. Question speculation. Here's the theory. Halo Beauty paying a plaintiff attorney bill and a defense attorney bill until it goes bankrupt. What could Swanson possibly gain from that? I don't know. Vindictive glory of like, fuck you. I don't know. But yes, Halo Beauty is involved in 2 lawsuits right now. And one of them is running up the cash. The other one, it's like, here's a motion to dismiss. We'll see y'all in September. Bye. So let's see what else. I should have seen your question, Anthony. I'm sorry if I didn't. Will you ask it again? Who's going to buy a yacht first? I mean, there's overhead and stuff on this for sure. So there's this is the kind of money firms make though. This case is just ramping up the bills for sure. I might have. I'm sorry. I do miss some of them because they jumped. I said that you and your hubby, make cute human puppies. Thank you, superhero. And again, when we have 6,000 people in the chat, some things do get missed and they don't stay up top for me in StreamYard. So I apologize when it jumps. Sometimes it jumps and I can't see them. I try to go and sweep through the top, but they don't always stay. And I apologize for that. I do try my best. Question, are there any updates? We haven't seen any updates in court. And let me see if there are any more. Question, could Saltz now ask to sanction Brown? I mean, it would be petty. And let's see. I mean, could Saltz argue like it's in bad faith to file the motion to shorten time? The court's already smacked it down. So does it need to happen? I don't know if it needs to be said. I think there's other things in the sanction motion that really need to be responded to. Does this error need to be responded to? No, the court's already responded to it. So will it be pointed out? Maybe. Has it been pointed out now? Yep, we're all here talking about it, but I just don't know. I don't know. For me, the thing I would want to do if I was opposing counsel looking at this after the court smacked it down the next day, and this was filed again on a federal holiday, so the court wouldn't have seen it till today. The court responded to it almost, the day that the court saw it, the court responded to it. So would I let it go? Probably, because there's other stuff in that sanction motion that would be more necessary to respond to. That's what I would think. So I'm going to try to get to a few more questions. And then my voice was getting tired this morning and it's getting tired now. If Tati wins, does KJ have to pay for Salty? Attorney's fees can be awarded on a lot of the counts in this case, so possibly. And if she doesn't, it's too expensive. How does Salty get paid? By his client. So yes, there can be. So we talked about this morning in the Keemstar case. Like Keem paid his attorney's fees monthly. His attorney's fees came in, and then he won attorney's fees from Romeo Lacoste, and then settled for a lower amount plus the play button. So Keem gets that money back from Romeo Lacoste that he's already paid out in attorney's fees. I'm sure that Tati is paying attorney's fees monthly, or that Halo Beauty is paying attorney's fees monthly and not Tati personally, because the business is involved in this lawsuit. So, how can Clark use Halo money if he cannot use Halo money? Clark, I don't think is using Halo money. So I just want to make that clear. Halo Beauty is paying to sue without a crystal ball, but Halo Beauty is also paying because it's being sued by Clark Swanson. So I think that's where the confusion is on that. I want to see if there is a not over this. Not over this. So I got to that one. Thank you. The chat scrolled back up and now I'm scrolling back down and I missed another super chat that completely jumped. Here it is. Unrelated, but how does it not drive you nuts to not have the matching straw in your Starbucks cup? Because I always need to mind match. It feels like it matches to me because oftentimes this shows up pink. So I like it. I don't mind it at all. I just want to make sure I didn't miss any questions because the chat is moving and grooving. Question. I saw what Brown makes per hour, but do attorneys charge some clients on a sliding scale like other professions do? It depends on the attorney and the firm and their overhead and the fee agreement on all of that. Yes, it can happen, but is it happening? I don't know. That's really between the attorney and their respective client. Can it happen? Yes. Does it happen? It depends. That they can say, hey, I'm not charging you full rate to deal with this or full rate to deal with that. That can happen. Thank you so much for introducing me to Rekieta Law's channel. His Facts Not Fuckery coverage of the impeachment trial was glorious and made me happy law nerd. I like Rekieta's coverage. His channel is definitely not a super PC channel. They have their own vibe. And that is, I always believe that there's room for everybody on the YouTubes. He's a very smart lawyer and gives good commentary. If you can take the jokes with it, there are definitely the jokes come with it. And it's not, I've had some come back and be like, I can't believe you were on his channel. I'm like, no, everybody has their own vibe. Some people are like, I can't believe she curses so much on this channel. We all have our own YouTube vibes. But Rekieta definitely leans heavily into the political commentary and knows quite a lot about it and makes it very clear where his perspectives are, where his opinions are. And I appreciate that because he's super upfront with what he thinks and how he feels about stuff. Oh, thank you, Christy. I appreciate that. I think that we've talked about this a few times. You would end up representing yourself, but the court has to let one out of a lawsuit before you can just peace out. Welcome to your first Tennessee winter. Thank you, Henhouse Bathco. It's been very, very fun. And we really enjoyed playing out in the snow today. Question, does someone need to file a conservatorship? I'm not sure regarding what Janice West that would be referring to, but there's a lot that it takes to get a conservatorship. So thank you. Question, when people keep lawyers on retainer, does that mean they are paying them for services before they are needed? Casey, me too. Yes. Most attorneys will take a retainer amount and then work that amount. Like, hey, you're essentially buying 5 hours, 10 hours, whatever it is. Once I've hit that threshold of 10 hours, then it's time to refresh the pot. Some attorneys don't work on that. Like, I'm holding on to 10 grand. And once we get towards the end of 10 grand, you're going to pay me another 10 grand before I do more work. Some attorneys work them bill. It just depends on the attorney and the way that the fee arrangement works and the way their firm's set up. There's that. Hopefully that answers it. What else? When you started off with y'all, I put down everything else because this was going to be something. Leslie, what did you think? There's not much else to say about it, really. It's interesting to me that this is how this went. And it's interesting to me that this was a very quick, the court very quickly went, this is not okay. The local rules don't say this. I'm sure that's not a fun minute order to get from the court over your email and be like, oh, great. This case will set new precedent in the legal communities. All lawyers will be issued a notebook with the shit I wish I could say in court but can't. Possibly, Your Honor, we have filed this motion to not delete your shit. I mean to preserve evidence. Possibly. Can sanctions be brought on an attorney without the other filing a motion? Like, can the judge decide? Brittany, in very rare circumstances, judges can on their own, like sua sponte, sanction attorneys. It's very, very rare. And it's something that the court would normally warn against before they would do it. It's very rare. But yes, it can happen. Isn't Swanson case debating jurisdiction? Yes, it is, but not until September. Could the KJ case impact that? I don't see how. Could they be related on that point? They're not related. It's in the Swanson case, the jurisdictional issue is, hey, Swanson's a Nevada resident. These companies are Nevada residents. This should all be in Nevada. It's a different thing. Yes, I'm working on sourcing Paw Nerd merch. So yes, it is on the list. Yes, I am working on it. Oh, and my chat jumped again. It goes in chunks for me, and it's like, and then I lose my place and can't follow up with it. So, question, does discovery happen before or after jurisdiction is decided? Kat, that's a great question. So normally after the beginning of a lawsuit, there is a time period in which discovery will begin. In this case, there was a stipulation that no discovery would begin until the jurisdiction was decided. That was agreed upon between the two parties. So for this particular case, this one, just this one, there won't be any discovery until jurisdiction is decided. And in that motion that we talked about, it feels like ages ago, there was one exception for subpoenaing Lori-Ann's social medias that seems to have been resolved by the fact that Lori-Ann handed over her social medias to Salty and was like, here, look at what it is. Is there such a thing as legal fee insurance in America? Yes, it generally goes with your business insurance, depending on what your business is, but not all online businesses carry it. Not all brick and mortar businesses carry it, and it doesn't cover all things. So a lot of insurance won't cover intentional acts. Some insurances would determine that things like defamation are intentional acts. So like everything, it depends. I'm going to get to a few more questions and then I'm going to bounce. We have been here over an hour. We have had over 6,000 law nerds on here live. Thank you for being here. Let's get to a few more questions and then we're going to go. I think mandating Zoom filters would make this case less contentious. No, it's federal court. I don't think they'll do that. It would be funny. Will the judge just go against, I think this is jurisdiction, just so she doesn't have to deal with all of this? Well, it's entirely possible. Most judges enjoy looking at the law of the thing, but it's entirely possible that the judge is like looking at it through the eye of these attorneys are going to be a giant pain in my ass. Or the judge can look at it through the lens of these attorneys are going to stay here and they are going to behave. And I am going to see to it. I have already had to read hundreds and hundreds of pages of shit. You all are staying here. But generally, the judge is going to look at the law and see if there's jurisdiction outside of all of those things. Question, speculation. Maybe Tati knows the connection between Swanson and KJ. She mentioned that the defamation and lawsuits and more in depth than anyone knows from her Breaking My Silence video. There are going to be things that we do not know that are known by the parties involved in this case 100%. So there are connections here that are hard to see that just feel too coincidental to me. Tati's been in constant emotional, my tongue just ran away with me. Constant emotional distress for 2 years. First it was James Charles, then it was Shannon Jeffries. Now it's without a crystal ball, perhaps Tati's the problem. And devil's advocate, always a fair point. But when it comes to defamation, the emotional distress part will only go to the damages part. So, my chat jumped again. Okay, I'm going to get to a few more and then we are going to go. Let me make sure I got these. I cannot believe that Brown, after KJ started this, is costing her a lot. She is running out of money to pay this suit. I don't know. I can't imagine that this isn't getting very expensive for all parties. But also I think some of that would be, client driven, because that's the conversation you have with your client is like, we can do this or we can do this. This is going to take us like this. And it's going to be, this is kind of what the cost is. We can choose to do this. We can choose to do that. It's kind of like door number 1, door number 2, door number 3. What do you want to do? These are all conversations that are had with the client. Litigation strategy is guided by the attorney, but at the end of the day, the client gets to say, yes, let's file this. No, I don't want to do that. Yes, you've advised me to do that, but I don't want to do it. Or you've advised me against that and I want to do that. So we will see what happens for sure. All right. So we're sweeping the last few questions. Thank you guys for the super stickers. Thank you for all the super chats. I'm sorry if I did not get to all of them. I do try. Good night. Good night. Thank you. Enjoy the snow angels. It is way close to twinkle twinkle time. That's for sure. Thank you for calling this. I know I didn't even do a full call to order. I wasn't intending to be back until Friday. We are going to do a premiere video tomorrow, but because the mods have doubled up tonight, I'm going to talk to them. I might just drop the video without the live chat so the mods can just take a break. So I'm going to talk to them about that. I will let you know in the morning what we're going to do. We're going to have a new video up. It might be a premiere. It might just be a drop. I'm going to talk to the mods. Perhaps KJ's lament over running out of money is only a tactical move. Who knows? Who knows? It's just so wild. This whole thing is so wild. Question, I think it was mentioned in the motion that the lawyers had a call to discuss this at the end of January. Do you think Salty knew that this was against the rules and didn't mention it? It depends on if the call was with all 3 counsel. There should have been a motion to confer. This motion should have been brought up. Again, we don't know the content of that conversation. Is it their obligation to say, I thought you couldn't make a motion to shorten time? Not really. Could they have said it? Yes. Could Brown have been like, I'm not listening to you? Yes. So we don't really know what was in that meet and confer call, but the court in the standing order says they have to meet and confer before filing anything. It would seem like the purpose of the meet and confer before filing anything is to not waste the court's time. So filing a motion that can't legally be filed is wasting the court's time, and that's something that's going to annoy Her Honor in general. But that's also part of what a meet and confer is for. It's like, we're not going to agree that you can shorten time. You can't shorten time. And Ron's like, okay, then I'll file a motion. They're like, but you can't do that. And he might just be like, yeah, okay, whatever, bro. We're going to do it anyway. So who knows? Thank you guys for riding with me this evening. I very, very, very much appreciate it. Why hasn't the judge brought out the gavel? I feel like this minute order kind of just brought it out and was like, no, we're done. It was pretty direct, and I appreciate pretty direct. I mean, that's what court orders should be. There's nothing else to say. Because there's nothing else to say. Motions to shorten time have been abolished. You should know that. That's what that says. That's all that is. You guys, we have been here. This is like over 3 hours of streaming today. Law Nerds, I appreciate you. Give a huge thanks to the Mod Squad for hanging in there so that we could ride again today, so we could just talk about this, because y'all, what in the fuck? Okay, I keep saying, I think we're done. I think we're done. I think we're done. I think we won't hear anything. And I'm going to say it again. I don't think we should hear anything until Salty answers this. And there's, 21 days from the 10th. So the very, very end of February, beginning of March is when we should hear something. Fingers crossed. Do I think we're going to get a full 21 days without hearing from this? No. Wouldn't it be wild if the judge was like, and here's my ruling on jurisdiction? That would be incredible. We'll see what happens. We'll see what Babs has in store for us. Thank you guys for being here. I have a new video for you tomorrow about my thoughts on framing Britney Spears. I have a new live for Friday Night Live. I have been reaching out, as I talked about this morning, to the people. I will probably have a special guest for you guys on Friday. I'm very excited. I'll let you know more of that during the week. And if you are new here, don't forget to do the YouTube things, the likey, subscribey things. Where are we at? We're at 85.8 thousand Law Nerds. And I just have to remind you, because some of you are new here, we got a few new things at the Law Nerd shop, and it's exciting. It's very exciting. So if you guys want to see the new things, head on over to the Law Nerd shop. We've got some new stuff. This is limited edition for the month of February. If you enjoy it, We will see it. True Sleuth, I agree with you. It feels like we'll hear more in this case tomorrow. It is the case that never ends. It goes on, and then. Anyway, we have some new stuff in the Law Nerd shop. For those of you that don't necessarily want the word fuck written on your clothing, we've got you covered. The crew neck sweatshirts go all the way up to 5X. The crew neck t-shirts, most of them go up to 5X. I am working on sourcing hoodies that go up beyond 2X. We are trying to make sure that everybody can find stuff they like. Mugs are printed on both sides, so all you lefties can hold your mug this way, or that way, or this way, or that way. It's like this and like that and like this, and it's like that and like this and like that, and it's like this. It's like, okay, we're going to stop. Anyway, that's all at lawnerdshop.com. You guys can go check it out if you want, and I will see you in the next one. Thank you for being here. I appreciate you so much. Talk to you Friday. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.